Welcome to The Explainer. Today we're going to talk about something every growing Canadian startup runs into. You're on the verge of landing a massive international client, and bam, you get hit with a bunch of complicated data privacy rules. It's the kind of thing that gets pushed to the side, right up until a huge deal is on the line.
Okay, so picture this. Your head's down, you're focused on your product, you're focused on growth, and then this legal document lands in your inbox. And it feels like it could slow everything down. It's that moment of dread that so many founders have been through.
But here's the thing, it doesn't have to be a panic. We're going to show you how to go from that frantic scramble to being completely prepared. And better yet, how to turn compliance from a roadblock into a real business advantage that actually helps you close even bigger deals.
All right, first things first, we have to ground ourselves in your foundation, and that's Canada's own privacy law. Before you can even think about tackling the global stuff, you've got to be a master of your home turf.
So you're looking at PIPEDA, Canada's big federal privacy law. But here's the absolute kicker for any startup that has global ambitions. Even if your province has its own little set of rules, the second your data crosses a border, PIPEDA is what matters. It becomes the baseline for absolutely everything else we're going to talk about.
Now, under PIPEDA, you got to think of data responsibility like a chain. It doesn't just stop with you. You're not only on the hook for how you handle data, you are also responsible for what your vendors do with it. That responsibility literally follows the data wherever it goes, from you to your partners.
Okay, so we've got our Canadian base covered. Now let's see what happens when your data, and more importantly your clients, are outside of Canada. This is where things get a little more complex for sure, but it's also where the biggest opportunities are.
You know, so many founders assume, oh, our data, it just stays in Canada. But think about it for just a second. What about your CRM, your analytics platform, your payment processor? A lot of these are US or international companies. Your data is almost certainly already a world traveler, whether you realize it or not.
And you absolutely need the answers to these questions. This isn't just for your own peace of mind. You're legally required to tell your customers about all this stuff. Transparency isn't just a nice-to-have buzzword here. It's a real legal requirement.
And this slide, wow, it just lays out the two completely different worlds you're stepping into. With the US, you're dealing with this complicated patchwork of different state laws, but in Europe, you've got one powerful, unified set of rules that you have to understand.
And you cannot just ignore GDPR. You have to follow it if you're intentionally marketing to people in the EU, or if it's reasonable to expect that people from the EU will use your service. We're talking even a handful of European users can trigger these incredibly powerful rules.
Now, this is a really key distinction you need to wrap your head around with GDPR. Think of it like this. Your client over in the EU, they're the controller. They're in charge. They decide what happens with the data. You, the Canadian startup, you're the processor. You're just handling the data based on their instructions. And that relationship dictates the exact kind of legal terms you need in your contracts.
Okay, so now we understand the landscape. Let's get practical. How do you actually prepare for the intense scrutiny that's going to come from those big enterprise clients?
Seriously, having these 5 things documented and ready to go before you even need them, it's an absolute game changer. It makes the sales process so much smoother. It shortens those painful security reviews, and it just shows potential customers you're serious and that they can trust you. And this is the real payoff. Getting all this stuff right isn't just about dodging legal bullets. It's about building that fundamental trust you need to close bigger, more profitable deals with really sophisticated customers.
All right, let's talk about the final tools you need in your playbook. This is how we turn all this knowledge into real, concrete action that actually protects your startup.
Remember that document from the very beginning? The one that caused all the panic? This is it, the DPA. And it's not just a formality you sign and forget. A badly written DPA can create these massive open-ended risks for your company, so you've got to know exactly what to look for. So when you get one of these, this is your checklist. You've got to confirm data is encrypted. Look at that incident notification timeline. Is it reasonable? Can you actually report a breach in 24 or 48 hours? And check out the audit rights. Are they predictable? Or can a client just show up and demand access anytime? These details matter so much. Don't sign up for promises your company can't actually deliver on.
And I know what you might be thinking. Ugh, lawyers, bureaucracy, costs. But please, don't think of it that way. Think of it as a strategic investment. A good lawyer spots the hidden time bombs in contracts before they blow up into huge, expensive problems later on. Let's wrap all this up with one final thought. which is really about reframing how you see this entire topic. It's time to move privacy from the bottom of that never-ending to-do list right to the core of your strategy.
So, you have to ask yourself this question. Is your privacy policy just a liability, a cost center, something you have to deal with, or is it a business asset? Because that is the key takeaway here. When you handle this stuff proactively, good privacy isn't a cost. It's a powerful tool for building trust, for standing out from your competition, and for driving real growth.